Good morning, everyone. I hope you're doing well. My name is Pramod Pandey, and in this lecture, we will begin our discussion on the continuing basis and look forward what are the areas that we have to cover, and we'll try to ensure that we are going to complete the very first part that we are on to the business, the basic legal system, and we'll try to cover on that, and then I will look around some of the questions from the Kaplan. The pending question together with the BPP and the ACC study is something that I will be assigning as a homework because we do have 2 days holiday. We will not be having the class on the weekend. So I will be assigning some of the work that you have to do. Is it okay? Now, I just want you to have a quickly go through to the things what we have done till now. Okay. Just a 2 minute on them. We will be on a good note. We would be in a better position to start with the things that I have planned to take from today. So we were having a discussion like this: business, political, and legal system. The basic thing that both of these three things are having or would be having an influence over each other. How business would be affected by the politics and how the politics will be affected by the legal system, or what is the legal system having an influence of the politics and business, right? What they would be having an influence. So somewhat you will see there is a single line that will be affecting. Suppose the politics will be making a law, right? And the law will be affecting the business. So somewhat you will be seeing the interaction between all of the three. Then we have been through the three type of the economical systems, which I have been very vocal about: the plant, mix, and the market. In the plant, the government is playing the major role. Market is basically the one where the demand and supply are deciding the things, the price and the buyer willingness and the seller willingness to sell for. These are the basic things that we'll be defining. Then we talk about the mixed economy. What is a mixed economy? It is a mixture of both the types where there is a suitable balance between the public and the private based on the condition of the country. Okay. Then apart from that, if we talk about the business, politics, and legal system, in the economical system, like there are three things, the same thing that we were discussing. Then we have been through the political system, and then we see what are the way through our political system can come. It can come through dictatorship. Dictatorship is basically one of the way where the military is going to be appointing one of the people from themselves. Then we have other way that is in democracy. In most of the countries, you will see democracy is there, where the people are given, the normal population are given to choose the leader by them by giving the voting to them. In India, this is what one of the famous that why India is known as the democracy country. Okay, so this is the thing. Then we know what is important about the separation of power. What will it help by having the same? Okay. Then we saw there were three type of the there were three types through which a separation of the power can be done: the legislation, executive, and judiciary. Because these are the three different roles. So one people cannot be going through, or one people should not have the power or the the authority of dealing with these three rules. Because the power, because we are dealing with the law. Law is very sensitive issue, right? One cannot be assigned the whole power into the law, because if that goes into that one hand, he would be available to misguide themselves. He would be in a better position to do things which would be not beneficial to the company, but which can benefit him from the objective or whatever the decision he's going to make. Okay, are you there, Samit?
Yes, sir.
So is my voice clear?
Yes, sir.
So they are the keywords that I have been I was searching for the keywords which you need to know. So Samit, they are the key terms, or better if I call them as a concept or terminologies, the law vocabulary, which we need to learn. Okay.
Okay, sir.
So I will be explaining the concept or the meaning of the thing, so it would become easier for you to get it done when you will be having the revision. So basically, there is a one word that is known as an invalid. Okay.
Okay.
Hello. So invalid means
Yes,
that
sir.
it is not legally accepted or usable. Not legally accepted or usable. Okay.
Okay.
Voidable means something is still valid, but for now, but can be cancelled under certain conditions. So it can, voidable means it is not cancelled now. Okay. But it could possible that say there might be some certain situation which would push it to the cancellation process. Okay. So invalid is
Okay.
something which is not legally accepted or usable, which cannot be used. It can be used, but if it going to be used, this will not be the legally action. Okay, this will not be a legally process. Okay, Something which cannot be used legally or accepted legally is known as an invalid. Okay. Avoidable means something which is not cancelled right now, which is there in the existence, but because of the future event, it could possible it can become cancelled. Okay.
Yes, sir.
When I do say illegal or legal, legal means something which is in accordance with the law. Okay. What it would mean when it is an illegal, it is against the law. Is it okay?
Yes, sir.
Null and void means that is not valid anymore, as if it is never existed. So when we were having discussion yesterday, I've been very vocal about the same thing, that if there could be anything, null and void means this has now been cancelled, or we will be thinking that it is not existed anymore. Okay. Hello.
Yes, sir.
Then we have unenforceable. It does mean that a rule or contract exists but cannot be applied by the court. Okay. And enforceable means
Okay.
something, if even you're not following the law, it will not be having a harsh consequences because it is unenforceable. The government cannot make it applied. Okay. Something which is not applied by the court, it becomes unenforceable. Okay. Cannot be applied.
Okay, sir.
Then we have a 3-way to call a cancelled. The very first one is declined. It does mean that contract or agreement is formally cancelled. Formally, okay? By mutual agreement or due to the problem. So whatever the problem was there, whatever the mutual agreement was there, because of these two things, now the contract has mutually cancelled between the parties, right? Example, if someone lied during the deal, the contract can be disclaimed. When the lies becomes open to the other parties, so in that case, we can call this as this is we might probably be looking to the mutual consent, or where we can mutually exclude or can get this contract cancelled out. So this is basically the process when we will be knowing as an disclaimed. So basically, there's a different way to cancel a thing. Okay, there are different ways to cancel a contract. Now one is declined, one is revoked, and third one is terminated. So we will be knowing about the definition, and we will be knowing the situation. So the definition will change accordingly when you are canceling up a project or canceling up a thing or canceling up a contract. And when you are doing the cancellation, is basically will define you whether it is an decline, revoke, and termination. So when someone has lied in the contract and now that lie or the basically the wrong has now become open. So in that case, both the parties will be doing the mutually cancel, or will be moving out of the contract. In that case, it will be known as a decline. Okay. Would it be okay if you explain this to me, because there was too many things I have explained you on the decline. I want a simple meaning what you understood from the same.
From the sign.
Yes, please.
It is like a contract or an agreement which is signed by two parties. But if there is any problem, they will cancel the agreement. Like if one party lies, and then the contract will be resigned.
So further, these three types also vary according to the nature of the product or nature of the contract that we're dealing into. Okay. The next one, that is revoked, it does mean that something that was given but taken back. Example, a driving license can be revoked after the breaking the traffic rule. Okay.
Okay, sir.
Then we have a terminated. Means any agreement is ended either because the time is up or someone ended it earlier. Example, a lease agreement can be terminated after giving a notice, right?
Yes.
So you cannot call termination as in revoked as termination. You have to be clear on these terms, okay?
Okay, sir.
So for you able to understood what we discussed till now, or the discussion that we had about this keyword, were you able to remember the same, or would you like to take a screenshot of the same? Because, or I would be asking you if you can just write up the things in your notebook,
Yeah,
or the one.
I already took a screenshot.
So can you please take it now? Because I have
I
erased
took
the
it.
things. Okay.
No, I took it
Wonderful.
before. I took it before.
Wonderful. Okay. Because there are certain things
Yes.
while I'm reading them, because this is the book I'm following is the new to me, because I know the concept. I have passed this paper, but it's still the one I'm using to teach you is the new one. So I'm just putting out the additional things which I'm thinking, okay, necessary, and this will further help all of us in having a better understanding of the concept, okay?
Okay, sir.
So that was the point. Now there is one more thing that I will be starting with, that is in conflict of interest, because we had a discussion about this criminal law and civil law. And Samvit, I would be requesting you to please have a good knowledge or good understanding on these areas, right? These are the important areas, and I
Okay.
would like you to have a focus on this. You can expect at least 2 to 3 questions coming out of here, okay? From this paragraph
Okay,
only.
sir.
Is it okay?
Okay.
So better to clear on this. And if there is any doubt, still if there is any doubt, you will find. So you know how you can assist me, okay?
Okay, sir.
Now we talk about the conflict of interest law. So yesterday we had a discussion that when I'm talking about there is a transaction or international transaction which is happening, so it does mean that there are the different companies which are coming together and then they're having a transaction, right?
Yes.
Hello. For
Yes, sir.
example, there is a transaction between India and Russia. Okay. Now
Okay.
it could possible that the trade regulations and rules and regulation would be a different in India, and it could possible that the trade and regulation rule would be a different in Russia. It could possible or not.
Yes.
Now, because there is a transition that need to be done, so we need a immediate or mediator who can facilitate this transition. Because ultimately now the India is saying that you have to follow my rules, and Russia is saying that you have to follow my rules, right?
Yes.
Because so this is the situation of the conflict of rule laws, right? Hello,
Yes, sir.
able to understand what I'm trying to convey?
Yes,
So would
sir.
it be okay to read this sentence till here?
A conflict of laws occurs when parties from different legal jurisdictions interact and trade with each other and their respective legal rules conflict. This is where international law steps
No,
in
you just
and
have
when.
to just give it a reading till here. Were you able to understand what
Okay.
you mean to convey from here?
Yes, yes.
So it's saying the same thing. Conflict of law will like occur where there are the different legal jurisdictions. So by the jurisdiction, I mean to refer a country, because it does mean that the area or the country whose law apply. When a country A is applying, when they are going for the trade, so they will be applying, or they want their trade rule will be applied into the transaction. Yes or no? But when they're dealing with the
Yes,
country B, so country B also want their trade rule need to be applied. So there is a requirement of the international law that will mediate them, and they will say A will not be going to follow the rule, B is not going to follow the rule. Both has to do, or both has to follow the rule which I have created. It could possible that he has incorporated some rule from the A country, he might have incorporated some rule from the B country, but it's saying that you're not going to follow from the your book, you're going to follow from the reference I'm giving to you. Okay.
okay, sir.
So
Understood.
this is basically the situation of the conflict of law, where the two different parties are there, where they want their rule to be applied, but this will make a situation of the conflict of law. And in order to deal with that, what you have to do, you just have to look around that the international law will take the step into. Okay, international laws step in and will regulate the relationship between the parties and their right and the duties toward the one another. So while reading this, you might not be able to understand what they're trying to convey. Okay. Huh? But
Okay,
when
sir.
I'm explaining you, you can able to understand that okay, the one thing that explaining can be written other way or in a simple word, okay? But that would
Yes,
mean
sir.
it is written in the English. As I've been very vocal about this to you, that the law language would be a different one. So you have to understand and you have to have a grip on the law language. So this paragraph would mean the same thing which I've explained to you. Now you can able to see what I've explained to you could have been written easier. Huh?
Yes, sir. Yes.
But there was some few words that they have incorporated, like jurisdictions, right? Like
Yes.
then international laws step in. Step in means they are getting into this. Andarana, है ना? They're getting
Yes,
into
yes.
the between the A and B country. So this is all what you have to think around. This is what you have to approach. You do not have to go around thinking that what is written as an English language. You just have to understand the things in the context of the law language, right? This will further help you in getting the things done. Is it okay?
Yes, sir.
Are you able to understand what does the conflict of law mean?
Yes, sir.
Now we will learn about the sources of law. So what are the, when I say that there is a requirement of the sources of law, so sources of law would be what? Okay, so the sources of law will be derived, means they are coming from where they are coming. Okay, so it has a various sources, different sources, three different sources like international treaties and conventions, international customs, and general principle of the law. So what are the treaties and conventions? These are the written agreement between the two countries. Okay. So obviously when
Okay.
their country A is making a contract between B, so there might be some term and condition, because ultimately when you are having a transaction, so there will be some term and condition. Without them, a contract is nothing, because ultimately a contract is what? Something you will learn in further. It is an agreement that is legally binding. Okay. Hello.
Yes.
Now the agreement will incorporate the terms and agreement, right? Terms and condition. Yes or no?
Yes.
Agreement is what? Where the two parties are agreed. So there will be some condition both parties are put into. There will be some terms both parties are put into. Hana? So when
Yes.
both parties has given the term and conditions, which will become the agreement, and once the agreement is legally binding, it will become the contract. Yes or no?
Yes.
This is basically the concept of the contract. But so when I do say that the treaties and conventions, so it does mean there will be some basic terminologies. Because of that, the contact is there. Otherwise, the contact will not altogether will altogether will not be there. Okay. So
Okay,
what
sir.
does it mean? That written agreement between the countries, they are formal and legally binding. Treaties are like contract between the nations. Once signed and ratified, they must be followed, and they create the rules everyone agrees on. Okay. So
Okay, sir.
what I mean to say that international law is the sum of three. One, two, three. So it is a sum of the three, and the first statement is this one, second statement is this one, third statement is this one. So when I do say the first statement, so it does mean that international law will be incorporating the things which are agreed between the two parties. Okay,
Okay, sir.
are you clear on this point?
Yes.
Then you have international custom. International custom says that these are unwritten rules over time. Custom means what is basically happen, what is traditions, right? Based on the consistent actions and mutual belief that they are legally required. Okay, so when I'm teaching, so ultimately my custom is that I'm teaching something very relevant and something very truthful. It could possible that I might not able to still know some few of the things, because it doesn't mean that when a teacher is teaching, they know every legs of the things, right? It could possible they might be, because improvement is a constant process, right? So when I'm
Yes.
teaching, so my custom would be that, or as a teacher, any custom would be that they're delivering something very good, or something very valuable, or something at least true. Okay, whatever they know, they're just delivering it true. Or whenever you performing your duties, even work, the studies, so you basically suppose yourself that you have to do this with honesty. Yes or no? So the custom,
Yes.
the honesty that is coming is basically your customs. Okay. So when there is an international transaction which is taking place, so what are the custom would be there? The transaction should be that the compensation would be paid by one party, the goods will be paid by the other parties. So it could possible. So the belief that I will be getting money, the other party would be having a belief that I would be getting paid the goods, right? I will be receiving the
Yes.
goods, other party. So these are the basically the honesty. These are the custom that they will be believing. So this is something legally. It cannot possible that one party is taking money and now they are saying, I will not provide you the goods. Hana? This is not basically what happened. This is just 1% of the custom what I mean to convey. Other 99% has to be understood like that. When something like some things are implied, they cannot be expressed every time. Whenever you are making a contract, something will be there already, whether you talk about this or not. Yes or no? So those something which are
Yes.
already implied is something the customs. Okay? Understood?
Okay, sir. Yes.
Unwritten rules followed over times based on the consistent exchange and mutual beliefs. They are legally required. Example: respecting embassies, protecting during wars. Customs grow from long-standing global practice. Countries follow them out of the legal obligation, not just traditions. Even without documentation, they are respected. Okay. The third thing that we have are the
O-
general principle of the law. General principle is basically these are the core legal ideas. Like we have a Constitution of India. In India, the Constitution of India will be known as in the highest law that we have, and that will formulate what are the role and responsibilities and everything, the framework that has to follow the country while making a new law or while operating through the legal systems, right? So the core legal ideas is basically the general principle of laws, right? This is another way to know what are the other implied general principles that are going to be taking place. Okay, these are the basic legal ideas that are common in most legal system around the world. Like fairness must be there, justice must be there, and due process must be there. Huh? They will fill the gap, and when there is a no clear duty or the custom to guide decision. So when we don't know that what should be done next, so we will be looking around what are the general principles is. Okay, these are
Okay, sir.
shared values across the many countries, like legal system, like treat other fairly, don't punish without a trial. They are often used by the court, like International Court of Justice, when there is no specific laws applied. So this is something important. A question would be there in a paper, and it might say that what you will be using when there is a no specific information, no specific international law will be there. So what you will be using, you will be using the general principle of law. So I have made a
Okay.
question from it. Hana? So this is what
Yes.
the depth of understanding that you require from the subject. This is what the depth of understanding that you require to knowledge or to be knowledge around or to keep in your head. Because ultimately, if you are not able to, you have understood this. Even if you don't able to remember this, you might be losing a marks on a thing that you should not be. Hana? Because this would be coming for 1 mark, 2 marks question. But if you know because you have been going currently, and what I would be suggesting you to just have a constant revision so that you remember able to remember the certain things, so that can further help you in retaining the knowledge or remembering them, so that because ultimately they can make a question from anywhere, right? A one single line they can post it the way I have just explained. I have made a question. Okay, if I can make a question from there, so they are the expert of me as well, huh? So they can do anything. They basically sit together with a couple. They are the 4 or 5 teachers sitting together and then studying the subject, and then they making questions. So the question would be coming out of like this. So you have to understand. You have to click on yourself on your mind. You have to tap on there to give yourself a hope that this type of the question can come from this area. How they can be posted. So whenever you reading or studying, so you have to understand. Okay, this is how one question can be there. Okay.
Okay, sir.
Now, so we have understood what is a conflict of law, and we know what are the sources of law, international law that we do have. Okay. Would it be okay if you allow me a minute? I would come back in a. Okay, but is it okay?
Yes, sir.
Thanks. Hello.
Yes, sir.
Now we will move ahead with the common law and the civil law. Okay.
Okay, sir.
So they were things you have been through, like criminal law and civil law. Those are the two things. Now, so it was because it is started with the C doesn't mean that it is the same criminal law. So those were the different topics that we have been through. Now we will learn other type of law that is in common law and civil law. Okay. So what is in common law here? So it is driven. Derived means from where it is coming. Okay, it's derived from the body of law which was stabilized. Stabilized means got into implemented, or which basically the time from when it got existed into the market. Okay, so it derived from the body of law stabilized in the England between. So there was a one body of law which was stabilized in England between this period. From that time, the common law is derived. Okay. Now there is a one thing
Okay, sir.
AD. What is an AD? So this is anno domini. This is a Latin word that says that years of the Lord. Okay. In the years of the Lord. Okay.
Okay, sir.
And this is basically used. When it is used here, it does mean that it is used to label the years after the birth of Jesus Christ. Okay. So when I say 10662 to 14000 AD, this was a time when the common law has taken place. So it does mean that 1066 years after the birth of Jesus Christ till 14 years after the birth of Jesus Christ. Okay, something very normal to come in the paper, but I'm just giving it for the purpose of making it understood for a knowledge perspective. Okay, because ultimately, if you're reading something, so we must understand what they're trying to convey. So this basically marks the beginning. So the common law which was there, it was from the time of Norman conquest of the England. Okay, so this marks the beginning of the legal traditions right after the Norman conquest of England. That's why judges start building an unified systems of law based on the court decisions, which later spreaded to many countries like USA and India and others. So first it started in the UK, then after the UK it has been followed by the USA, India, and other countries, right?
Yes.
If in a summary, if I just give you the basic meaning, what is a common law? Common law is basically the case law. Sometimes this is in common law, sometimes as in case law. Okay, there might be a situation, I'm not pretty sure about it, that could it be possible that case law and the common law can be different, but because I'm not able to recall it currently, but sometimes this is in common law, sometimes as in case law. Okay, so that the court would be having a case. Okay, when any case comes to the court, hello,
Yes.
they just give the information to the court, like this is what happening. Okay, after analyzing everything, the court made a decision, yes or no?
Yes.
So noting what was the case, noting what was the decision which has been given according to any law, if it has been followed, completing or accumulating all of these three, we basically write all of these three in a one book that is known as a case book. Okay, and that gave rise to the case law. Okay, so in that case law, there are like legs of case has been written like this, like the similar way. Okay,
Okay, sir.
so have you understood what does the case law mean?
Yes.
What is that? Hello,
Yes, sir.
what do you have understood from the case law?
So when the courts have cases, they make the laws and then they write it in the case books. And then from the case books, it becomes case laws.
Can you able to put a light on why the name has been given as a case law? Because ultimately the law you're making is based on the case which you have heard in the court, right? So that's why they are naming it as a case law. Anna?
Yes.
Perfect. Now we'll learn about the core principle of the civil law, okay? And it says that
Okay, sir.
principles of law do not get irrelevant with time. So it could possible the case law which was made in 15 years, when was the time, and it cannot be that okay, the law which was there will not be followed in 2022, 26, 25, or 26, whatever we are following. It could possible, but ultimately they are the things which will define whether it can be possible to follow the same case law which was made in the previous hundred of years, thousands of years back. Could it be possible? Yes, it could be possible that there are certain things we have to look around. Like the case should be similar, right? The parties or the happening in the case should be similar. It should not be that the basic of the case are different, right? In a case one, there was something else was happening. In the case B, something else was happening. So we cannot formulate a single opinion on both of the two cases because those two cases are different in nature. The characteristic of the case are different, right? If this is something
Yes.
happening in that case, we cannot say that the decision which was formed will going to be applied because it cannot be there because ultimately the characteristic of the case are different, right?
Yes, sir.
So when I do say the principle of law do not get irrelevant, yes, they will not be getting irrelevant with the time. Just because of the time because the law was made in 15 years back and now the time is that, it doesn't mean that the law will become irrelevant while the time it reaches over here. No, this is what not happens. It could possible that the law which was made in 15 years, 15th century would not be applicable in this year. It could possible, but this would be the situation when the characteristic of the case are different, right?
Yes, sir.
So ultimately, what you have to look around, you just have to look around on the characteristic. What are the characteristics are there? Characteristic, the natures, these are the two things will define whether the previous law, which was formed after giving the opinion on the case, will be followed or not. This will define whether we are going to follow the same case or not. The rule of the same course or not, right?
Yes.
Now I need to erase it a bit so that you be in a better position to understand what we're discussing till now. Okay. So are you able to understand what when you say that the principle of law do not get irrelevant with the time? New laws are
Yes.
assumed not to alert. So whenever there is a new law which is getting there, obviously there was a one law which was there in 15 centuries, right? And there is a one law which is coming after 2 years, 3 years. So it doesn't mean that it's going to change the previous law. It could not going to be possible, right? But it could possible that you are making a new law with the intent of changing that previous law. This is your scenario. If you have an intent to change the previous law with a new law, in that case it will be replacing. If it is not with an intention, so we will not be assuming that it will alert the previous law which is there. Okay,
Okay, sir.
are you able to understand what we are discussing?
Yes, sir.
Judges must exercise the law and use a judicial precedent. So judicial precedent says that, for example, because in your other paper of the ACCA you will follow the IFRS, right? The reason of IFRS which is there, like all the MNCs companies has to prepare their financial statement on the IFRS, and it is a reasoning because this will give you the consistency over the years, right? You have a same rule of the standard that you're going to follow each year while making the financial statement. Yes or no?
Yes.
Now, when I do say there was a case one, there was a case two, the nature and characteristics are same in these cases, and you have given something XYZ decision in the previous case, and the nature and characteristics are the same like previous one. And in this case, if you're giving the decision Y, Z, or something else from this, so in that case, you're not going to be following consistency, right? So other party would be saying that, okay, you have followed this decision previously, even though the characteristic and the nature are the same, why you're not following the same decisions? So this is what the problem, because we are not going to be consistent, right? In order to ensure the consistency is there, but consistency will only be considered when the nature and characteristic of two cases are same. Okay, so in that case we have to look around, could it be possible to follow the previous case which is there? Okay, the decision of the previous case. So judicial precedent, it does mean we will be learning this in the later period, but for the timing what you have to understand, the judicial precedent means you are going to follow the decision of the previous case. Okay,
Okay. So if
but
there is
when it
any case, if there is any case similar to the previous one, we'll follow the same thing.
but you have to be very
Okay.
specific about that nature and characteristics should be similar. Hana? They
Similar.
should be identical. Hana?
Okay. Yes.
Understood? So this is what the judicial
Yes.
precedent says. Judicial precedent means the decision made by the judge in the previous cases, right?
Yes.
Is it okay?
Yes.
Perfect.